Okay, so in this video, again, we're talking about theater and law. And this is part of towards a theatrical jurisprudence, but I'm going to read you some different stuff, or we're going to look at some different stuff. So one of the things we need to do is first look at the word theatrocracy. It's a noun which means a government run by the people gathered in a theater, such as the Athenian democracy. The word comes from the Greek theatrokratia, which is a combination of theatro and kratia. Kratia. So democratia was the word for democracy, which meant government by people. So now we're looking at theater by people. In Plato's laws, theatrocracy is described as a musical theatrocracy that will lead to a more general theatrocracy. Plato describes theatrocracy as the opposite of the rule of law and a threat to destroy it. Now, some people have said, and you've probably heard it, that it's as if our government is being ran by Hollywood, right? So we've heard this, and there's an article here that explains this, but this is also sort of in this book, Towards a Theatrical Jurisprudence by Merritt Legoff, which is what we've been going over. So we're just going to go over this article, uh, Theatrocracy Unwired, Legal Performance. So remember we talked about performatives and how to do things with words by J.L. Austin and the modern metasphere, he says. So he goes over the abstract. We'll go over the abstract here. And this is from 5 May 2014. So writing in the middle of the 4th century BC, is an age of mass trials and dramatically trained rhetoricians. Plato worried that Athens was becoming a theatrocracy, a state ruled by theater, in which audience applause or catcalls determined verdicts and established laws. In the 21st century, with legal news, television trials, reality police shows, YouTube execution videos, etc., shouting at us from our many screens, Plato might think his theatrocratic nightmare had come true with a vengeance. In our theatrocracy, where the media is ever online, TV spectators can determine guilt or innocence. Are the boundaries of the legal system beginning to dissolve? Does theatrocracy threaten laws, stability, legitimacy, autonomy, and authority, as some have argued? Is theatrocracy a threat to nomocracy, which is its opposite, to the very existence of law? Theatrocracy Unwired looks at the nature of our legal theatrocracy from the age of television to the age of the internet, the theoretical discussions of law and media, the anti-theoretical anxieties awakened by the swelling of the large media sphere and the significance of these in the force and meaning of law. So he just kind of goes over some of the reasons for his article here, and shows on TV and judges and stuff like that. So let's just get it right into the article, which I think is a really good article. In his famous passage in Book 3 of the Laws, Plato launches into an excoriation of what he terms theatrocracy or theatrokratia, the role of theater, which he opposes to the philosopher's rule of law. His real object is a defense of the rule of law, generally, but he begins with an extended trope on the degeneration of musical discipline into musical license, which figures the more general degeneration of law into theocratic license. In former days, he writes, the educated made it their rule to hear the performances through in silence, in order to pass verdicts on them, and, in case of need, to penalize the infraction of the rules that governed musical composition. Where necessary, they used the discipline of the official's rod on the boys, their attendants, and the rabble at large as a means of enforcing order. The bulk of the populace willingly submitted to this strict control. However, several of those ignorant of what is right and legitimate and possessed by a frantic and unhallowed lust for pleasure took over from the earlier generation. They inspired the multitude with contempt of musical law and a conceit of their own competence as judges. Pleasure became the measure of judgment, replacing standards of right and wrong, and music was thenceforth governed by the clapping of applauders or the catcalls of discordant outcries of the crowd, which pronounced judgment by its clamors. Thus, our once silent audiences have found a voice, and the persuasion that they understand what is good and bad in art. The old sovereignty of the best in that sphere has given way to an evil sovereignty of the audience, theatrokratia. For Plato, in short, as expertise began to disappear, the sovereignty of the most popular, determined by the uneducated rabble, displaced the sovereignty of the best. Criteria of rational judgment were supplanted by pleasure as the ultimate criterion, driven by unhallowed lust. The audience, following its desire blindly in pursuit of pleasure, ceased to believe in right and wrong. Relativity, aesthetic and moral, was the conscience. Musical theatrocracy was unfortunately only the beginning, for it opened the door to a more general theatrocracy. If not stopped, this general theatrocracy would ultimately lead to a wholesale escape from obedience to the law. For it was musical theatrocracy that had given the rabble undue confidence in its own powers in the first place. Starting with music, there grew the opinion that all are competent in everything, as well as the rejection of laws. And liberty has followed in their train. The next stage of the journey toward liberty will be refusal to submit to judges, predicts Plato, and on this will follow the effort to escape obedience to the law. The spectacle of the titanic nature of which our old legends speak will be reenacted. Man will return to the old condition of a hell of unending misery. Here, the excess of theater threatens nomocracy, theatrocracy's antonym, the measured and rational rule of law, kept pure of theatrical taint. However, in Book 7 of the Laws, Plato cast unruly, pleasure-driven, emotionally excessive theater not as the opposite of rational, measured law, but as its rival. One of the reasons, among others, that poets, dramatists, and actors must be excluded from the Republic. As Plato's Athenian explains to the tragic dramatist, we lawmakers are ourselves authors of a tragedy. Thus, you are poets. And we are also poets in the same style, rival artists and rival actors, and that in the finest of all dramas, one which indeed can be produced only by a code of true law. So you must not expect that we shall light-heartedly permit you to pitch your booths in our market square with a trope of actors whose melodious voices will down our own, and let you deliver your public triads before our boys and women and the populace at large. Let you address them on the same issue as ourselves, not to the same effect, but commonly, for the most part, to the very contrary. Why? We should be stark mad to do so. Actors and playwrights must be banished, not because they are agents of theatrocracy against the bulwark of nomocracy, but because they compete with and challenge legal theatrocracy, the theater of law. Seducing women and boys, those same boys once ruled by the ordering rod, they threaten law's monopoly on seduction. They drown out law's harmonies with their own melodious voices. In Plato's account, in Book 3 of the Laws, of the musical theatrocracy that will lead inexorably to a more general theatrocracy, theatrocracy is the opposite of the rule of law and, in fact, threatens to destroy it. In Plato's explanation of his banishment of actors and dramatic poets in Book 7 of the Laws, theater is law's double. It's same yet contrary, which must be destroyed so that law may have sole theatrocratic power. Plato's coinage, theatrocracy, appears only occasionally in the history of Western philosophical discourse. It is most notably present in Nietzsche's The Case of Wagner, where it indicates not the power of seductive spectacle to sway the laws, but the domain of theater over the other arts, the nonsense of a faith in the precedence of the theater, and the right of the theater to lord it over the arts, over art. But even if infrequently referenced, Plato's double position reflects an ambivalence about theater that deeply remarks the entire history of law. In philosophical discussions of its foundations, function, and meaning, and jurisprudential discussions of its doctrines and techniques, and popular accounts of what law does. In these discussions, theater stands for the sensuous passions, the deliberate inflation of the sphere of emotion, the rule of pleasure, and the sovereignty of the dissembler. Law stands for reason, the control of emotion, the rule of discipline, and the sovereignty of truth, enforced by the discipline of the ordering rod. Where law represents well-ordered soul, theater is a kind of madness, the realm of illusion and hallucination, falsely divine and disturbingly dangerous. It is, however, universally, if unhappily, acknowledged that law is, after all, a performance art, an art of public rhetorical suasion in which compelling stories dramatized before the relevant audience, judges and juries, ultimately shape legal outcomes, often making doctrine simply irrelevant. On the one hand, in order to preserve its identity, law must suppress its own tendency towards spectacular, hysterical, emotional, visual, seductive, theatricality in the name of maintaining discipline, what is just and legitimate, and the role of expertise. It must avoid the degradations of theater, skewering its dignity and rationality through its disavowal of theatrical means, at the risk of a hell of unending misery. On the other hand, as backup for the not always convincing ordering rod, it must employ every theatrical art in its means: sensational narrative, emotional stirring speeches, dramatic staging, images meant to terrify and arouse. I hope elsewhere to offer a fuller account of the significance of such ambivalence about legal theatricality for legal history, for its claims, its doctrines, and above all, its self-staging as event and practice. Here, my central question is present and future directed. What happens to legal performance and to the simultaneous desire for and fear of theatrocracy in the modern discipline? Theatrocracy in the age of television, theatrocracy in the digital age, the information bomb, the society of control or the emancipated spectator. Conclusion. The conclusion of law's exploitation of new media and its resistance to them, we can find a replay of Plato's ambivalent attitudes towards the theatrocratic world he feared. For the blogosphere, theatrocracy, old and new, threatens law as it ought to be, subordinating the concern for justice to the drive for narrative and scopic satisfactions, displacing the role of expertise with the role of the vision machine, driving a deduced populace invisibly controlled by a frantic and unhallowed lust for pleasure to pronounce judgments by its clamors. Theater, the rival artists and rival actors who pitched their booths in the electronic marketplace and addressed the populace on the same issues as law, but commonly threatens law from the outside by competing with it and undermining its monopoly on judgment. At the same time, it threatens law from the inside, degrading its practices and rendering it as histrionic and mendacious as theater itself. In reaction, law acts, on the one hand, as theater's rival, attempting to harness the power of theater as its own, propelling itself into the metasphere to publicize and dramatize its gospels. On the other hand, denying and repressing its own theatricality, law asserts a countervailing democracy fitting in its ostensible dignity. For Deleuze and Virilio, rivalry has become merger. Law has leagued itself with theater to exploit its power, and the theater of law has become indistinguishable from the digital media that serve it, in a systematic collaboration in which law draws the theater's power to produce together a society of control. Here, the legal subject is under continual surveillance, both object of the perpetual vision machine and controlled by its imaginary reality. For Ranseret, the theatrocratic, on the other hand, theater stands against the police in a war between Nomocracy and theatrocracy, in which, if theater does not destroy law, law will destroy theater. But what and where is this vaunted Nomocracy, this eidos of the law? Dispassionate, rational, perfectly unspectacular. Perhaps true Nomocracy is reserved only for the production of administrative regulations, corporate contracts, tax rulings, or the handing out of parking tickets. But even the most excruciatingly boring law can be produced in the crucible of mass emotion, tinged with the extremities of passion, verging on the histrionic. All the more so any police encounter, trial, or punishment. Even the most authoritarian legal machine is messy, prone to error and embarrassment, more like the Keystone Cops than the perfectly choreographed blue-suited killing machines in The Matrix. Perhaps if true democracy exists, it exists only behind the curtain of the law, produced through a divinely dispassionate sacerdotal ritual performed by judicial high priests whose neutered vision cannot degrade it and who have no emotions to taint it. Maybe it has never been seen because its very exposure would instantly transform it into theatrocracy. This would mean, in a sense, that democracy exists only as an imago, made visible only in the mirror of the theatrocracy. It would mean that democracy, far from being contaminated by theatricality, is created by it. an otherwise invisible and phantasmagorical other, but for the antithetical theatricality that breathes life and form into it. Democracy does not need theatricality merely as something to be against, as for instance, anti war activism needs war, or as an object for expertise, as for instance, anti global warming needs global warming. Neomocracy needs theatricality as the vehicle of its creed, without which it would be invisible and inaudible. Watching legalism thrive in the digital media sphere, one comes to realize how parasitic democracy is on theatricality. Theatricality does not, as Almong puts it, erode law's potency and validity, its specific meaning, its credibility, or as Elaine Supiut suggests, cause law to decline, while the symbolic collapses, or, in fact, in the least attenuate its power. On the contrary, its augments law's opportunities. The ever-present media may seem to some to pervert law, but as we have seen, its presence means more law in more places more of the time. Law's struggle with media theatricality produces a plethora of new issues for judicial pronouncement. Issues of a highly media genetic kind. Will cameras be allowed in the courtroom or will they not? Could the dash cam video of Ricard tasering Buckley become part of the judicial opinion? Is a YouTube video of a drunken Amanda Knox admissible as character testimony? At the same time, legal theatricality produces a countervailing anti-theatricality. What a media circus, what a farce, that serves as a buttress for the claims of democracy and is supremely effective at making legal subjects internalize law as their very own. Without the pleasure of condemning a trial for its failure to stand fast against the depredations of theater, the pleasure of one-upping the law's official masters of ceremony and proving oneself more legal than thou, law would lose half its charm. Far from being bad for democracy, theatricality appears to be not only good for it, but also necessary to it. One senses that Plato knew this, and that his distinction between theatrocracy and democracy was merely an ideological ruse. For his democracy was always already in part theatrocracy. We are rival artists and rival actors, he tells the tragic dramatist. It was always already shot through with the theatricality that it always disavowed. If the opposition between theatrocracy and democracy is false, however, it is nonetheless integral to the theater of law, internalized as part of, indeed essential to, the experience of legal spectatorship. This opposition operates to sustain the ideology of law's separateness, its distinctive temporal and spatial borders, as Almong puts it. And thus the distinction between law and not law. Much of law's legitimacy is, in fact, vested in this distinction, but the barriers are difficult to maintain. What is it that makes Judge Judy or the Buckley YouTube video or a virtual tour of the Meredith Kercher crime scene not part of law proper? Is Ricard's dash cam film part of law in the minutes he was tasering Buckley, but not part of law when posted on YouTube? If it belongs inside the courtroom for law, but outside for media, where does the courtroom end and the media sphere begin? During the trial of Rudy Grude, officials put paper up in the courtroom windows with masking tape and a low-tech dramatization of the principle of judicial secrecy, where the judges and other spectators inside the courtroom, clearly distinct from those who peered through the cracks in the masking tape, and those clearly distinct from those who watched Grude walk through the halls of the courtroom on their computer screens. Are these severable from law proper merely because they happened outside the walls of the courtroom or appear as images thrown into the media sphere? To do battle against media trials or the mediatization of law is to buy into law's ideology about itself. The idea that law is autonomous from other spheres, the idea that law is not theater, and indeed that its legitimacy is grounded in its successful resistance to the temptations of theatrocality. And is it a losing battle? And it is a losing battle. Law will never resist the temptations of theater because law's very being is a theatrical one. But it is a battle that will continue to be waged because anti theatricality is equally central to law, an essential self authenticating mechanism. And as it turns out, the fact that law is a hopelessly theatrical medium may not be the hell of unending misery that Plato envisioned. For theatricality, passion, and even hysteria do not necessarily vitiate law's decisions. Sometimes the more histrionic, the better. One cannot help but think of the Chicago Seven. This does not mean that unregenerated theatrocratic thought, though one may be unregenerate theatrocrat, though one may be, one must elaborate all moments of high legal theatricality, the Salem witch trials, or the Stalinist show trials, or the grotesque theatricalization of torture in Abu Ghraib come to mind. But it is not their theatricality that is wrong. It is the substance of what they've done. So in Austin's book, he does talk about um, not being a part of the game. So he talks of performances and less of theatrics. And he says that if a bunch of people are playing a game and they say, here, catch the ball, and the one guy standing to the side says, I'm not playing, by the fact that he said, I'm not playing, uh, he's non-played. And so he's not involved. He's not part of the game. And then we get into Austin's six parts of the performance, the first four being void when not properly done, and the last two being as verdicts or something an umpire, a judge, or a referee would do. May be happy or unhappy, but not void. So just a comparison here between theatrical jurisprudence or theatrical law as opposed to Austin's performance and how they differ a little bit. And this man seems to think that, well, like he says that Plato says that you can't really have one without the other. And I've read a lot about how law is just persuasive speech. Judges use persuasive speech, attorneys, lawyers, they all use persuasive speech to sway people's opinions and to accept their verdicts. So he says, this person writing this article, I didn't catch his name, I didn't say his name. Julie Stone Peters, this woman, she says, like Plato, you just can't really separate them. Maybe we can write laws without theatrics, but when people go to court, that's when theatrics come into play. And back in those days, they used a stick to um, discipline the officials and the boys and their attendants. The discipline of the officials rod on the boys, their attendants, and the rabble at large, and as a means of enforcing order. So it's like the judge's gavel, I guess you could say. So, an interesting article. I'll post a link into the description, and I've got another video on stupidity and entertainment that I'm going to post a link to, and it's done by Sam Vaknin. He's got this video out. I don't agree with everything he says, but I also think it's an interesting take on society and how it's moving towards a more entertainment society and what that might look like in the future. And so good stuff here if you're into it. And like, share, subscribe. I'll see y'all later.